Can a disinherited child contest a will? Have you ever wondered what happens when a child feels left out of a will? This situation can lead to many questions, especially when it comes to the legal rights of disinherited children. Let's break down how a disinherited child may contest a will and what that process looks like. In the realm of estate planning, a disinherited child can contest a will under specific circumstances. This means they can challenge the validity of the will in probate court. The first step is understanding the legal grounds for contesting a will. A disinherited child might argue that the will was created under improper conditions. One common reason is lack of testamentary capacity. This means the person who created the will, known as the testator, was not of sound mind when they wrote it. Another reason could be undue influence, where the testator was pressured or coerced into making certain decisions. Improper execution is another ground for contesting a will. If the will was not properly witnessed or signed, it may not hold up in court. Additionally, if there is evidence of fraud, such as the will being altered or forged, that can also be a valid reason to contest it. To move forward with contesting a will, the disinherited child must file a lawsuit in probate court. This process involves presenting evidence that supports their claim. The court will review the evidence and make a decision. If the child is successful, they may be entitled to a share of the estate. However, it is important to consider the practical aspects of contesting a will. This process can be emotionally taxing and may incur significant costs. Consulting with an estate planning attorney is essential to determine if there are valid grounds for contesting the will. An attorney can help gather necessary evidence and representing the child in court. Another factor to keep in mind is the statute of limitations. In many jurisdictions, there is a time limit for filing a will contest. For example, in New York, a will contest must be filed within 2 years from when the will is admitted to probate. Lastly, contesting a will can impact family relationships. It is vital to consider these potential consequences before proceeding with a contest. Understanding the rights of disinherited children and the legal framework surrounding will contests can help navigate these complex situations.